call the Pennington County Commission meeting for September 20th, 2013 to order. We'll stand for a moment of silent reflection and the Pledge of Allegiance led by Holly Hennis.
Thank you.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hey, Don, you can tell these young kids.
Thank you. The next item is to review and approve the agenda. Does anyone have any changes
For that.
they wish to make to the agenda? If no one has any changes they wish to make to the agenda, do we have a motion?
Make a motion to approve the agenda.
Second?
Second.
Motion and a second to approve the agenda as printed. Any discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Next item is the consent agenda.
Good morning, Commissioners. Holly Hennies, Commission Office Manager. For full public notice, the Board of Commissioners uses a consent agenda to act on non-controversial and routine items quickly. The consent agenda is acted upon by one motion and vote of the board. Items may be removed from the consent agenda and placed on the regular agenda at the request of a board member or a citizen. Today, I've placed the following items on the consent agenda for your consideration. Approval of the minutes from the regular meeting of September 3rd, 2013. Approval of the vouchers in the amount of $2,687,292.15. And to schedule a public hearing on October 1st, 2013 for General Fund Supplement SP 13-013 for the Accumulated Building Fund Tower Project budget.
Does anyone wish any of the items from the consent agenda removed?
I move to approve the consent agenda as presented.
Second.
Motion and a second to approve the consent agenda as presented. Any discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Next item is item 8, which is the second reading and public hearing for ordinance 106.
Mr. Chairman?
Yes.
I've got to, since I kind of was the one who proposed those, I've got some questions that I would like answered and probably some changes made in it. And since Jay is not here today, I'd like to make a motion to postpone item 8 and 9 till the next meeting.
Is there a second?
Second.
Motion and a second to postpone item 8 until the next commission meeting,
8 and 9.
both 8 and 9.
Yeah.
Okay.
The major problem is
Any discussion? If not, those in favor of the motion say aye.
that'll not fly.
Aye.
Aye.
Did we get,
I was listening, sorry.
Kind of a stair step.
well, we made it anyway. The motion passed.
Goodness.
Next item is a Pennington County, item 10, Pennington County resolution to honor the 2013 South Dakota Hall of Fame inductees, Jerry Schoner, Ruth Brennan, and Pat LeBrun. Is there any discussion? Commissioner Davis, I think you were the one who called this
Yes.
to our attention.
Mr. Chair, I did bring that up, and I'd just like to read we'll call it a resolution. Pennington County resolution to honor the 2013 South Dakota Hall of Fame inductees. Whereas it is right and proper for the Pennington County to give special recognition to the outstanding citizens, and it is important to celebrate the contributions made by dedicated individuals in shaping our community. And whereas Jerry Schoner, Ruth Brennan, and Pat LeBrun were inducted into the South Dakota Hall of Fame on Saturday, September 14, 2013. And whereas Jerry Schoner is a Rapid City native who served in the Pacific during World War II. After returning home and completing school, he began working at the Rapid City Journal, where he stayed for 50 years before retiring. Schoner also served as a state senator for 8 years and Rapid City Common Council for 12 years. And whereas Ruth Brennan has been essential to the Rapid City Arts season, she has served as the president of the Rapid City Concert Association and the Rapid City Arts Council. She was also executive director of the Dahl Arts Center from 1975 to 1998 and was an arts columnist for the Rapid City Journal. And whereas Pat LeBrun's contribution came in the world of education, where she served on the South Dakota Board of Regents for 18 years, including 2 terms as board president. LeBrun helped expand South Dakota universities from teaching-only institutions into more research-based learning, and be it therefore resolved by the Pennington County Board of Commissioners, on behalf of the citizens and communities, honor the 2013 South Dakota Hall of Fame inductees, Jerry Schoner, Ruth Brennan, and Pat LeBrun. And in recognition of this induction, urge all Pennington County citizens to join in appreciation of the contribution these individuals have made to our community and to our county. In witness thereof, I hereunder set my hand and cause the seal of Pennington County to be affixed hereto this 20th day of September 2013, and I ask that we pass a resolution to allow this chairman's signature to that resolution.
Is that your motion?
Yes.
Do we have a second?
Second.
Motion and a second to adopt the resolution as read. Any further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried.
Thank you, Mr. Chair.
Thank you. We have item 11. Holly, what's your advice on executive session? With Jay and,
The other parties are here, sir.
okay. So with that, next item on the agenda is executive session for contractual and pending litigation. Is there a motion?
I move to go into executive session for contractual pending litigation.
Is there a second?
Second.
Any discussion? If not, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Do we have a motion to come out of executive session?
So move.
Second.
Motion and a second to come out of executive session. All in favor say aye.
Aye.
Opposed? Motion carried. Do we have another motion?
I'll make a motion to hire the law firm of Gunderson, Palmer, Nelson, Ashmore LLP to proceed with the discussion that we had on issues in executive session.
Is there a
Second.
second?
Second.
We have a second. Any discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Item 12. Items from Information Technology Department. Russ?
Good morning, Russ Tinsvold, IT Department. So my first item this morning is a request to go outside of the wage scale for a specific position. And just by way of explanation, what I'm asking for is to move a specific individual from 19C, which is where we hired this person at in June of this year, up to 20C. Now, to explain it further, what we originally planned to do back in June was to hire somebody and hire them somewhere around the 20C range. But the individual that we hired didn't have supervisory experience, which is what we were looking for, but was a good fit in every other way. So instead of taking the chance of hiring somebody in a supervisory position with an appropriate salary and then finding out that they wouldn't be a good supervisor, what I opted to do was to hire them at the next grade down at 19C and then work with them for the next few months and see if they could be our supervisor. Well, fortunately, this person has done an outstanding job. So now I'm ready to move them into the supervisory position, and I would like the salary to match that position. But I'm almost there. I can go up to 19B without coming to you and requesting that you take a look at it. But I'd like to go just a little bit more to make it a more appropriate salary. So that's how I got into this position. I took a chance when I went ahead and hired them at the lower position in an effort to be frugal with our resources in case it didn't work out. So I'll stand by for questions.
What's the difference between a B and a C?
In dollar-wise?
Yep.
So a B would be, if we're looking at hourly, 20B would be $24.48, 20C is 2509. So in the course of a year, to go from B to C like I'm requesting would be somewhere around $1,200 additional per year. So I'm not asking for anything just, way out there, but I do think that's going to be just enough to make it appropriate for this position.
Any other questions or comments? Nick, do you have anything to contribute?
What I did with Russ is we met on this. We discussed where the appropriate step was. He indicated he wanted to go more. I told him some of the history of asking for these out-of-class wage increases. He was comfortable with the request. He was comfortable with, and I was in on the decision to bring the person in at 19 at the lower level to give them a chance to prove themselves at 20. He's been an excellent employee as far as I can tell and everything else. And so that's where we brought today. I don't make recommendations on these. Hasn't worked out well in the past, so he knows what he's doing. But we reviewed it, and all the proper steps are being followed.
Thank you.
Mr. Chair,
Yes.
one of the things that I appreciate about why you did it this way is that you had a person who had the skills technically, but you weren't sure if they had those supervisory skills. And sometimes mistakes are made when we go ahead and put them into that supervisory position, and they just can't be a supervisor. So for me, I could support this much more than normal simply because of the fact that we took the time to find out if the person could indeed be a supervisor.
Mr. Chair.
Any other? Yes.
So, am I understanding you right that back in earlier this year, when you were advertising for this position, you were advertising it as a 20C?
I don't know that we actually, well, Nick, do we post
It was a
the,
28 through D.
yeah, A through D?
A through D, and our pay policy allows us to hire new hires in that range?
Correct, yes.
Okay.
I have a question, Mr. Chair. In the title, it says request to reclassify IT Specialist 3 from 19C to 20C. In the request part, it says be reclassified, IT Specialist 3 be reclassified to an IT Systems Analyst at a 20C.
That's my
What do-
error. So the lower part is correct. What we're actually.
We're not reclassifying the title, we are reclassifying the person into a different
Correct, and I
job.
apologize, that was my error.
Any other questions or comments? Do we have a motion?
Mr. Chair, I would move to reclassify the IT Specialist 3 to a 20C.
Is there a second?
May I just make a quick comment on that? I'm not sure that's the correct motion.
Oh, okay.
Because as Mr. Buskerud said, we're not asking to reclassify the position,
Just the,
just this individual.
okay. I apologize. So it will be the individual now in?
To a 20C.
Okay.
I'll second that.
Moved and seconded to grant the reclassification. Are you okay, Karen? Any further discussion? Not those in favor of the motion say aye.
Aye.
Opposed? Motion carried.
Thank you.
Thank you. Now we're on item B, preview of the new county website.
So this next item, I hope is something that you're going to be excited about. We're getting very, very close to pushing out our new website. What you see right now is our existing website. So I'm just going to spend a couple of minutes just giving you a quick look at it, and then I'll answer any questions you have. So this is our existing website, and just to cover how we got here, the existing website hasn't been updated in 7 or 8 years or more. And over that course of time, in addition to beginning to look very dated, a lot of information has been added, and it's started to get very fragmented. So it's very difficult for people to find information sometimes, and it also is difficult to show how transparent we are in sharing information with the public. So this is your look at the home page of our new website. We did have a committee that worked on this design along with our vendor, and the committee represented the majority of our departments here. That big picture that you see in the middle is Mount Rushmore. That changes every time you go to the home page. It randomly selects one of about 5 different pictures, and I'm going to show you what the other 5 look like. And we can change these, but these are pictures I got from the Department of Tourism that we're allowed to use. And we're just trying to get some random pictures here throughout Pennington County or very close to Pennington County. And, you know, we have opportunities to represent specific things like Ellsworth out here. Now, once you get off of the home page, we no longer have that big picture. The big picture is just on the home page. So here's an example of what the Highway Department's page looks like right now. What we're trying to do, among other things, is keep very consistent information. So when you go to the department, the Highway Department page, for example, on the right-hand side, you see the department head, their physical address, their hours, their phone number. It doesn't matter which department you go to, you're going to see that information in the same place, which is easy for the public to get a hold of us. In addition, the center part of each page is editable by that department, so they don't have to rely on making a request to the IT department. They can just get in and change it themselves, which will allow them to keep the information very accurate. Just a couple of other quick things I'm going to show you here. That we've got and these are all linked from over here on the left-hand side. All of these links show up on every page. But if we go over to our Contact Us page, it's got email address, how to email us, and phone numbers, and links to the department pages for every department in the county. Over on the left-hand side of every page, we also have this search by topic, where we've just got a list of common things that people are trying to find. They want to get a marriage license, they want to get license plates, they want to check on their property tax information, things like that. And the last thing I'm going to show you here is we've got a page that's just dealing with government transparency. Now, we do a very good job here at Pennington County of putting a lot of information that the public want out here, but in our existing website, it can be a little hard to find. There is a movement throughout the country to sort of test and verify government transparency, and one of the ways they do it is to look at your websites. Right now, we don't have a very good rating when it comes to that, not because we don't have the information out there, but because the information is a little scattered and a little hard to find. What this does is this just puts this transparency link on the left-hand side of every page, and it just says, hey, here's the main information people are looking for, and here's how you get to it quickly. So it's just an effort to kind of raise our status in the transparency realm, so to speak. So it's just going to make us, it's just going to highlight that we are a transparent government. So with that, I guess I'll stand by for any questions.
Questions or comments?
Well, the group of department heads that worked on this and so on, they were really, really committed, and I think they've done a nice job of making it look pleasant, but also putting the information in a little better format. And I like that we were starting to have departments that were putting out their own website, and now we're going to be able to come together in that, and I think that's important.
Any other comments?
Looks very nice.
Yes.
Thank you.
Thanks.
Thank you, Russ. Okay, next item is item 13, proposed Cane Creek Land Exchange. Martha Witcher.
Hello, I'm Martha Witcher, Emily Township 24 clerk. Thank you for seeing me. I'm here today to let you be aware that our township has not had any coordinating with the Forest Service, again, with this proposed land exchange. This isn't the first, the second, the third. This is the fourth time. We go on record everywhere we go, reminding and relaying to them, by law, they have to coordinate with their local and county governments. In the packet that I had laid before you, I put together some congressional laws that state that they have to and must be in a planning process with the local and county governments. I'm going to read just a couple of these just for the general public. One of the things that it says, county officials in particular have the responsibility to protect the local tax base, value of private property, economic stability of towns and intimately associated with natural resource production, the well-being of the school system, and in general, the well-being of the local community. These criteria functions are closely entangled with federal management decisions. Congress has long recognized the importance of local authorities to the management of the federal lands and to the actions of resource management agencies. It also says on the other page, the burden to comply with these coordination mandates from Congress is the federal agency's responsibility. Local governments which understand the rule of coordination are in an important position to insist that their community not become endangered by federal and state land use regulations. When local governments require federal agencies to coordinate with them, they are simply requiring the agency to follow the federal law. Failure on the part of said agency to coordinate means it's breaking the law. In the packets, you'll see the reason that we're here is that we have asked and brought to the attention coordinating efforts of what the Forest Service has to do. They have since sent out a letter dated September 16th, interested party. I've talked with Katie Kundra at the governor's office. It's supposed to be my understanding of a coordinating law, and I'm not a professor at Cornell University, but they would get together with the township and the county. We would sit together with the Forest Service or the federal agency, whatever, and we would formulate a plan. That's called the coordination. Then the governor's office, according to congressional law, has to have notification 60 days prior to public notification or public input. I've talked with Katie Kundra from the governor's office, and what she sent to me is that the governor's office has received the same letter that states they're going ahead with their plan. I read the law that the governor should be getting a statement from the township and the county saying, we've worked with this agency, we can be for or we can be against these proposals being taken off. These parcels that they are presenting, which we were not notified they were coming to you folks at this last county commission. We weren't even said they were on the agenda. Thanks be to your Secretary Hawley, we were able to find out that this is going on at a county level. These parcels that they have sent, that I got from Jane Darnell dated September 16th, states that this property is leaving Pennington County and going to Fall River. It also states in here that several of the parcels belong to Emily Township. Emily Township maintains its stand that we do not and cannot afford any land to be taken off of the tax rolls for any reason. Also in the packet that I gave to you, you will see that we had a letter in there that we had written along with I had sent an email to the head Forest Service person, Vicki Westling in Washington, D.C., asking her about how can this be done without the coordinating effort. I got an email response from Cindy Hockelberg stating, and she cited this law, 43 U.S.C. 1716, that gives several agencies the authority to do that. Well, the interesting thing that was not in part of her response is I researched that same law. And the very beginning of the Federal Land Policy Management Act 43 U.S.C. Section 1712 says, and I quote, has required the Secretary of Interior to include local government officials in the federal land use planning process so that they will have a voice in policy planning and decisions which impact private land. It goes on to say how imperative Congress has seen local and county government be involved in this. And this is all in the packet that I have set before you so that you can see this. Emily Township feels, and we would like to work with Pennington County, this is the fourth time we feel knowingly, on record, this is all the information we have, They are knowingly breaking federal law. I will also cite to you from a Forest Service use book, which is in your packet as well. It comes from the Forest Service, United States Department of Agriculture, the use book 13. Regulation 36 CFR, the Forest Service is obligated to consider and provide for community stability in making this progress. We've seen the stability of the prairie dog town in the Kanawha Basin of that management and the devastation. 36, well, it just goes on. The Forest Service is obligated to coordinate with local governments. The Forest Service is obligated to meet with local governments to establish a process for coordination. Even in their own use book, they are going against the laws. There are several things that a person, and we don't have time to allow it, but they are obligated. It just continues to say it over and over and over, not only on the congressional law base, but it says it also in their own use book. What Emily Township would like to do is to coordinate with the Pennington County and join together and request a full accountability, a full audit of this proposed Cane Creek land exchange at the Washington level with the Department of Interior and the Department of Agriculture. Because according to these laws, there should be meetings on file. There should be steps that have been done. Instead of just coming before the county and leaving the townships completely out, there are supposed to be meetings that should have been had. We would like to work with the county, write a letter together to those organizations and say, we want, talking about transparency, we want a complete accountability of what is going on in our local governments, that we have been told this is how it's going to be.
Any questions or comments?
I get a little excited. It's my dad.
That's all right, Martha.
Mr. Chairman, I agree. It's time we do something with it.
Yep.
My problem is I'm not sure 100% of what's going to be the end result, because, you know, if they take a hike, I'm not sure you can even sue them. But it's worth a try to, especially with the townships and the county, we need to get together and say, hold it, this is enough.
I think that we need to, if I can, may I reply?
Yes, you may.
What I would like to do is, Commissioner, I understand what you're saying. What I would like to do is what the law is saying. The county commission have to follow these laws, and the townships have to follow these laws. If the county gives a township a directive, we have to follow your directive. What I would like to do is send a letter and notify these agencies in Washington, D.C., that according to this law, there has been nothing done unless we have repeatedly at meetings requested it, and then nothing is done. So I'm just asking for a letter of notification and a complete accountability for those offices to do and respond to us.
How about the congressional delegation?
Yeah, that's fine.
I have contacted all of them, and Mark from John Thune's office, his response to me was he could not understand this was going on again. And we haven't even taken into the account, and we have Representative May here as well, we haven't even taken into account the liability of loss of private land, of what the Pennington County, this affects all of Pennington County. Affects the people up north, because you folks have a job of balancing your budget, and we don't need any more land taken off.
I agree.
They're not following,
And I mean,
following the law. Should we ask the U.S. Attorney to investigate them?
Sure.
I'm sorry, I didn't hear that.
I just said if the Forest Service is not following the law, maybe we should be asking the U.S. Attorney to investigate them.
I agree 100%. That's called accountability. Because there are federal laws that are in your packet before you, Commissioner, that numerous times have been broken. And it's up to us to bring the accountability. You're right.
I don't know what kind of motion we're looking for, but I'd make a motion that you appoint one or yourself to get together with Imlay Township and draft a letter for us to send to congressional, to the U.S. Attorney, to anybody else we can think of. Tell them that the law's the law.
In that respect, and Martha, would it fit your timetable if the draft letter was brought back to the next commission meeting for approval?
If that would work for you folks, Emily Township is very appreciative of us working together with you to draw a line in the sand and say this is enough.
Okay,
And if you need some help, I'm sure our state's attorney would be more than happy to help you.
And with that, I'll second the motion.
Okay, now, were you making a motion?
Yes, I was.
And Karen will translate that.
Where it is on the tape so I can listen to it again.
Okay. And Commissioner Davis seconded the motion. So we have a motion and a second. Is there anyone else who wishes to comment at this point? Come forward, please.
My name's Carla Jolson. I'm from Pennington Township, and we concur with Miss Martha and would also like to be part of the letter. And we oppose the taking the land off the tax roll.
So in that respect, Imlay and Scenic Townships, would that fit in the motion as
That
you?
would be,
Money from the board from Scenic here, so.
I think I said that, but you maybe didn't hear it.
You betcha. That,
Anyone else that wishes to comment? I think we have the motion and the second.
she said she wants to say something else about the motion.
Yeah.
If I could just encourage, I would encourage the commission, I know you guys are very, very busy, but the stock growers are having their convention next week here at the Ramcota in Rapid City. And on Friday at 10:30, the stewards of the range, Margaret Bayfield, will be speaking. And she's very knowledgeable on laws and rules and regulations. And I think it would be a good opportunity to learn and grasp information and gather. Nothing beats the congressional laws, but I mean, she's a very wealth of information on this. So, but I'll be in contact with Holly then.
Is that the Ramcota?
It's at the Ramcota, yes, sir.
Okay, we have a motion and a second. Any further discussion? If not, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Thank you, Martha.
Thank you, commissioners, for your time.
Item 14, lien request, release request. Who's here to represent that?
Is this one for Susan McConey?
Yes.
I'm TJ Watano. It's with VIP Properties.
So, Mr. Chair,
Yes.
It's my understanding that that Mr. Roney has other properties as well. And we have been attaching to this one, but it would move to those other properties if we released from this particular set of properties.
So, am I incorrect to say that this action, if we pass it, would be more of a transfer of a lien than it would be a release?
Yes, and it stays with, Mr. Roney will not be released.
It would just be released off of 337 Main Gate, which we're trying to close on.
Which you're what?
Which we were trying to close on, well, last week, but obviously that didn't happen.
Were these two parties married or?
No,
divorced?
no, Susan
Yeah, I
was
guess I don't
married
follow
to,
what-
Susan was married to Brendan Casey, and she received the property in the divorce settlement. And then Mr. Roney had a contract for deed with Mr. Casey, but it was never recorded. So when they came, when Mr. Roney quit paying in 2012, they went to go and did the property and owner's encumbrance from Pennington Title Company. It wasn't on there because it was never recorded as a contract for deed. Well, once they did the quitclaim, the contract for deed got recorded as well. And Mr. Roney had the lien against him, which then attached to the property.
Mr. Chair,
Yes.
I'd just like to clarify for the public knowledge and ours, do you have the authorization from them to represent these people in this matter?
Well, I've got a listing agreement with Susan McConey to, I guess, no, I don't, though.
Okay. Mr. Chair?
Yes.
I'd like to make a motion to postpone this till the next meeting so Jay and Patrick could advise us what they think is the right thing to do with this. That's what we have legal authority for.
Okay, do we have a second to that?
What's that? What's the motion? Sorry.
To postpone it for the next meeting until Jay and Patrick can get involved.
I think I would second that.
We do have a second. Any discussion on the motion?
So we can't, so if Susan was here, would that not get pushed to the next meeting then? Is that the? Because she's in class right now, she's a teacher, so that's why I was here on her behalf, I guess.
We,
And
Holly, we could consider moving this down on the agenda. Is that appropriate?
We could, I don't know if this will help you. Jay sent this to me when we were in Spearfish about
And
what he thought about it.
Mr. Chair,
Yes.
we,
If you
we've
want to read that.
questioned whether or not he has the right to represent anyone, but the letter is signed by Susan and her request is in writing. So I'm not sure why we would need to worry. I don't know that he's representing anybody. I mean, she's represented herself in writing.
Well,
I think I was just trying to help with the
Yeah.
facts to help her be able to sell this property that she's basically,
Does
Was
Dave
given to-
Roney have any legal standing on this property?
no, he doesn't. The quitclaim was filed in December of 2012 back to Susan McConey for lack of payments. If they would have known that he had a lien against him, all they had to do was file foreclosure instead of a quitclaim, and that lien would have been released anyways through foreclosure. Because it's not against the property, it's against Mr. Roney. So they just did it
Roney
back-
had this property for a period of time.
on a contract for deed, correct.
And how long did he have it as a contract?
2 years.
Probably all we got is personal touch.
April 2010
Drag it out of them.
to June 2012.
The motion Jay says would be.
And he obviously signed the quitclaim with no problem back to Susan, but what they should have done is they should have just filed a foreclosure, and then advertised in the paper, does anybody else have anything against Dave Roney? And then it would have been released anyways, so this was just the hard way to get there, I think.
Okay, we've had some discussion off the record, and is there any clarification from that?
Well, not really in my mind, Mr. Chair. We don't know for sure whether this gentleman has other property that this is automatically attached to. Holly did say that she thought that he had other property. But I think that's why we hire attorneys, is to find out exactly what we should do in this matter, and both of them are not available to be here today, so I don't think a one meeting stance is gonna hurt anybody real bad.
Mr. Chair, Holly, can we have Patrick come down if,
I can get it over here.
so,
Postpone this.
postpone
Or
it.
table it for a little bit and we can get back on.
Okay,
That'd be good.
So I would make
you
us,
withdraw your motion and second?
yeah.
No, we just postpone a vote on it till later in the meeting.
Okay,
I think the only other thing, the buyers wanted to close for 2 weeks now and take possession of the property, and obviously we weren't able to do that because of this lien on there. So, and then it takes 2 weeks after you guys decide to even get it released off a title, if that's the case. So, it affects the buyer as well of the property.
Yeah. And what we're saying is we want to get someone from our state's attorney's office down here during this meeting.
Okay, perfect. Okay. Thank you.
I think that's right.
So was
I
motion-
still think we need either withdrawal of the motion or a substitute motion.
Mr. Chair, I would make a substitute motion that we postpone action on item number 14 until the state's attorney can attend our meeting and advise us.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Opposed? Motion carried. All right, we'll move on then to item 15, which is a request to set a speed zone, Clear Creek Placer Road District. Please identify yourself and
Oh, I will.
proceed.
Thank you, Mr. Chair. Morning there, Commissioners. My name is Bill Bigley. On 12 September, I generated some paperwork that was handed to Ms. Holly. Hopefully you got a copy of our request. And our request, for those that are in the public that may not know, in 1997, a road district was formed for North Prairie Creek, South Prairie Creek, and Clear Creek roads. That whole area is less than 3/10 of a mile. For those unfamiliar, where the location is, it's off of Highway 385. If you're familiar with the Black Forest Inn, if you ever dined there, going toward the south Pactola entrance, there's a dirt road off to the left called Edelweiss Mountain Road. You go up exactly 8/10 of a road to the photos that I showed, and you have Edelweiss Mountain Road and Prairie Creek. You take that road to the left, past the mailboxes. Incorporated in this are 2 consecutive blind back-to-back curves. And it imposed safety concerns based upon my past predecessors that rather than impose a higher speed limit, they asked for a 10-mile-an-hour speed limit. This 10-mile-an-hour speed limit took in consideration not only the driver, but those passengers in those vehicles. It took in consideration pedestrians and wildlife. And when I say wildlife, you can also include farm animals. We have cattle, bulls roaming the streets. And one of the most important people that we try to protect is our children. Not to convolute the information that's in front of you, but used as a catalyst, one of the powers of the trustees of the Board of Trustees for the Road District is to enforce rules. Being a retired Marine with 27 years and a former military police, I didn't have those hats on that day. I had the road district hat on. After making an attempt with the complainer, I won't use a name here, y'all have that information in front of you. But on 6th July, I noticed a vehicle exceeding the posted 10-mile-an-hour speed limit. This wasn't the first time, and it wasn't the last time. On this particular evening, we had accumulated much-needed rain. It was a very moist July in the hills, and we appreciated it. I followed the tracks that led to Maury Road. It was getting a little dark outside, and I had my Ben Franklins on, and I read the name that was on the tree. As I approached that house, lights came on, and the occupants knew I was coming because they have a very loud dog. The vehicle that I had noticed going through our neighborhood exceeding the 10-mile posted speed back in 1998, in 2013, on July the 6th, belonged to somebody in that household. I've always been one and taught from a good family, instituted by the Marines, that when you can keep dirty laundry cleaned in-house, you do so. Well, this has reached the level where investigator Ryan Cook had to do an investigation for me for stopping a vehicle not doing the speed limit. But on that particular 6th July, I had introduced myself as Bill Bigley, that I was the president of a road district, And I'm not sure if that individual driver wasn't paying attention, unaware, or was in a hurry. But I had asked that gentleman that if he could let the people know within his household that if it goes to our property, that our property is 10 miles an hour. We left cordially, and off I went. I talked about this at our Clear Creek Placer Road District meeting on 13 July, and actually complimented our neighbors to the south, since it is a public access, for doing the speed limit. I mentioned that family as well as another family who uses our road pretty much on a daily basis. That information was transferred into our minutes. It hasn't been approved. I've got a copy if you'd like to see it. And pretty much it just said everybody was doing a great job. Well, that particular day, on the 14th, I was doing some lawn work. And a vehicle about 2:30 in the afternoon goes through the property faster than 10 mile an hour posted speed limit. That evening, like clockwork, that vehicle comes through our property. That particular evening, I stopped the vehicle in the middle of the street. I identified myself once again, asked them if they were part of that family. They said yes, they were. Asked for the first name, which she did not need to give to me, nor did she, because she was a minor. And the rest is in front of you. Our founding fathers that built our road district had a great vision. Even in today's fast, everybody wants to hurry up and get home quickly. There are some instances where a 10 mile an hour speed limit was right by our Board of Trustees. What we missed was a key ingredient to the recipe, so that stands today. And we failed to come to the board and ask the commissioners, in accordance with South Dakota codified laws, 32, TAC 25, TAC 9, TAC 1, to recognize the 10 mile an hour on a very, very small residential speedway, one lane, 20 feet wide, with two entrances, South Prairie Creek and North Prairie Creek. You have two vehicles coming on the same road, somebody's got to give. That's where we're at today. I provided you with photos so that you can see those photos. The 10 mile an hour has been enacted well over 15 years. There's been an increase of property from the public coming from our south. And if you look at that police report, that individual happens to live on Maury Road, and the primary access to Maury Road is off of 385, not North Prairie Creek, not South Prairie Creek, and sure enough, not off of Clear Creek. We have no problem with anybody using our road. One thing I've learned is to put the word out. And I can tell you, I'd rather have a 10 mile an hour speed limit sign, speaking as myself personally, than to have a think sign in our road district. Is there any questions?
Heine, whose jurisdiction are these? Road district or county?
It's if you look at that last enclosure I gave you, the road district comes up with their speed. In order for us to establish it as a speed zone, then the county, in accordance with 32, TAC 25, TAC 9, specifically says that if you enforce it as a speed zone, then it can be enforced by local enforcement.
Under our jurisdiction, not your jurisdiction.
Yes, sir.
I think our highway superintendent there has an answer to the question that was asked, and I'd like to hear what it is. So if you just step over for a minute, let him speak.
Yeah, when a road district forms, all the roads within that road district become public public roads. And the road district trustees or supervisors, trustees, have the right to establish ordinances, laws, whatever for that road district. So, but in order for, if they do establish a speed zone, it has to be approved by the county commissioners before it becomes enforceable by law enforcement. Because if there's no resolution by the commissioners setting this speed limit, if they pick somebody up and go to court, it's not enforceable. I think Don probably knows that. So the county has to approve the speed zone set by the road district.
We may.
They may, yes. The only issue I have, 10 mile an hour is awful slow, and it's very, I mean, it's difficult to get people to slow down for a regular speed limit. There's 3 instances in state law where they have a lower speed limit than, state law says any residential area is 25 mile an hour whether posted or not. Then there's 3 other laws that said if it's school zone, you can go down to 15. And if you have an obstructed intersection where you cannot see that intersection, it's blind, then when you get within 200 feet of the intersection, the speed limit's 15. And they also relates to railroad crossings. If the railroad crossing's obstructed, then you can lower it to 15. And I guess, to me, I think 10 is too slow. I like to see 15 reserved for those very dangerous areas, and 25 is in a residential area. This road being narrow and some sight distance, it may justify a 15, but not a, I don't know, 10 is, and how do you determine somebody going 10 mile an hour? It's, you can just about walk that fast, so I don't know. I have little issues with the 10 mile. Plus, if I look at the pictures and if you look at their signs, in order for those signs, they have to be visible, they have to be placed at a certain vertical height, they have to be so far off the road, the bottom of the sign has to be 5 feet.
7 feet max.
Yep, right.
Thanks to Mr. Ken Hauser.
Okay.
Those have been made. Those have
Okay.
been adjusted. The other cosmetic little signs are just reminders of 10 miles an hour.
So if we grant a speed zone, they still have responsibility to sign it.
Correct.
And have we granted the speed zone of 10 miles an hour?
No, you have not.
That was just,
that's
they've
his-
never come to us to
That's
do
his
that.
request today.
So, do we have, do we have minutes that your Board of Trustees gave you the authority to come and ask for that 10 miles?
As a board of trustee, I have that.
I want more than just the comments about people.
This is 1998 minutes. Sorry.
No, but have you had
For
a be?
you today to be here, do you have anything that gives you the,
There's a guy in the back.
yeah,
Yes, ma'am, I wrote that. It says on that letter, we did it on behalf of.
but we don't have any proof of the motion that you were given this authority. That's what I was looking for.
Any other questions? Yes, Commissioner
Just a
Holloway.
couple. What's the speed, how long is the road district's road? What's the length of it?
The longest portion is gonna be, including, is 3/10.
3/10 of a mile?
Yes, sir.
And when you enter into this 3/10 of a mile,
Yes, sir.
what's the speed limit on that particular road?
There's nothing all the way up until you see the sign, 10 miles an hour. Coming off Edelweiss Mountain Road, Edelweiss Mountain Road is 25 miles an hour.
Okay.
That's a 2-lane road.
All right.
This is a single-lane road,
All
okay?
right. I'm just trying to clarify in my mind what the speed limits are. What about when you get to the other end of your 3/10 of a mile?
Those are all unimproved. So whatever they have.
Okay, and they're in a residential area?
Yes, sir, they're also in the residential area.
And how many people are members of this road district?
We have a total of 5 households off to the east side of Prairie Creek, and we have 15 homes off to the west side of Prairie Creek. That's exactly where our
You have 20 residences in this road district?
yes, sir. And if they're an active landowner, then they can participate. If they're registered to vote, then they can vote.
Well, are you imposing taxes as a road district tax?
Actually, we work through Julie Pearson's office to levy taxes, and the purpose is to manage, maintain, and improve our
I
roads.
understand what it's for, but you're imposing taxes on all 20 residences.
That's correct.
Okay. And have you checked with the sheriff on a recommendation on what the speed limit should be?
No, I did not. I can tell you from a personal loss, having a 8-year-old, 6 months and 1 day, get struck by a vehicle, and that was in 1989. He would have been 32 years old and 10 days old today. So from a personal standpoint, I can tell you that speed kills.
No, I don't disagree with that. Probably isn't anybody here that disagrees with that concept. Thank you.
Any other questions?
Mr. Chair?
Yes.
In these minutes, it doesn't give him the authority to come and ask for this.
Okay, do we have anyone else who wishes to comment? Yes, sir. Come forward, state your name.
Bill Nordemeyer, I'm one of the property owners in the road district, an old engineer, acquaintance of a few of you. Back in my college days, which I won't say how many years ago, but I had an ambition to be a traffic engineer. That lost out to being in the construction business, but traffic has always been an important part of my life, and as I went on in my profession, I've hired lots of traffic engineers and spent thousands and thousands of dollars on engineering studies, designs, all kinds of stuff. I live on one of the blind corners in the road district. I have property on both blind corners in that road district. Commissioner Holloway, answer to your question, the first about 100 feet off Edelweiss Road into the road district is U.S. Forest Service. And we really don't have permission from them to put a sign, 10-mile-an-hour sign at that. 10-mile-an-hour sign is within very few feet of being onto the road district. The other end of the road district, which is South Clear Creek, has a 10-mile-an-hour sign on it. These are properly sized, located, and height signs that were recently posted. In answer to the blind question, the clear sight distance from point to point as you're coming around a corner is probably less than the 200 feet that the highway superintendent spoke about. I can personally tell you that on 2 separate occasions, I met individuals I know that were far exceeding the 10-mile-an-hour limit. Once on my trike, once pulling a very heavy trailer. Both times I was right to the very edge of the road. The one individual is notorious in the valley for speeding, ended up on a right side with his right tire in the creek. We are very limited in this road district, 20-foot platted right-of-way. We've never said it's a private road. We've always said it's a public road. 20-foot right-of-way, you take out of that in a normal standard. As an engineer, take a 4-foot ditch out of each side, that leaves you with a 12-foot top. 12-foot top, you don't pass at much more than 10 mile an hour at the very best. So we got 2 blind curves, both with sight lines less than 200 feet. Not to argue against your highway superintendent, but I think the 10 mile is probably about as safe as you're going to get. How do you enforce 10 mile an hour with a speed gun? Probably pretty tough, but I know that in Pennington County there are other 10 mile an hour speed limit signs. Silver City, I think, is a classic example of that. So just, my experience and consult to this commission is that the 10 mile an hour for the first half of this 3/10 of a mile road is very reasonable. If, I'd invite, if you want to postpone this for a couple of weeks, I'd invite any of you to meet me on that road going more than 10 mile an hour, and you'll surely have a second thought about it. Thank you. Any questions of me?
Was that an invitation to play chicken?
You bet, sir. Any kind of beverage you'd like to drink. We're, matter of fact, Sunday afternoon at 3 o'clock, you're certainly welcome. We're having an open house at our house, which I did increase the tax roll in my district by a bit with a little bit of an addition on homes. So at an open house Sunday afternoon if you like to show up. So.
Yes, Commissioner Holloway.
I'd like to, I see Chief Deputy Mueller is here, and I'd like to see if the sheriff's office, which would, if we pass this motion, is going to be taxed with the enforcement of this, and if they've got any recommendation, or if they've been out and looked at this.
Yes, sir.
Hello, Brian Mueller with the Pennington County Sheriff's Office. If you're looking for an actual recommendation from us, I'd ask that you postpone this until the next meeting and give us some time to put some information together, and we'll get that sent over to you.
Okay, I think that's what we should do, because if we pass this, then it makes it enforceable for law enforcement, and the reason they're here is because they're having trouble, and so you can bet as soon as we pass this and it becomes effective, they're going to be calling the sheriff to get out there to slow these people down. And so, I think we should have the sheriff's office on board with a recommendation on what they think is a reasonable enforcement effort in that area. So I'd make a motion to postpone it for 2 weeks and have the sheriff come back with a recommendation.
Is there a second?
I'll second that, but I'd also like to make sure, we have these road districts come in and people just ask that, and there, if you've got minutes that give you the authorization to come in and ask for this sort of thing, I'd like to see that, because that is not on here. Okay, thanks.
Thank you, Chairman. Thank you, Mr. Chairman.
Thank you. Okay, we have a motion and a second. Any further discussion? If not, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. In the way of a personal privilege, this whole reminded me of a story about a situation in Elk Point, South Dakota. And apparently over the years at the intersections, they had cement sidewalks across the street to the other side. And as time went on, they put gravel over these, and they were having trouble with speeders. And finally, the old postmaster and a couple of other guys got to remembering that the sidewalks were underneath that gravel. So they just dug out the sidewalks and made speed bumps. And that slowed everybody down.
I bet.
But anyway, are we ready with Patrick to move back to item 14? Patrick here, and have you had a chance to?
Yeah, I'm familiar with the lien release request.
Okay, so what are your questions for Patrick?
Mr. Chair. Patrick, do we have any other hold on this gentleman other than this particular property? And do we have any hold on him on this contract for deed?
Well, on him personally, the obligation to repay the county for court appointment attorney's fees follows him anywhere. But
That's
it is
true,
a lien that attaches to personal property that he owns, or an interest in personal property, which is what's created by the contract for deed. So I don't know if he owns any other, if he has an interest in any other property in Pennington County or elsewhere in the state right now. But if he does, our lien would attach to that as well. He did have an interest in in this property for a time. And so the lien attaches to that, and under our law, it doesn't go away just because he quitclaims his interest in the property. So the lien stays with the property, although it's also an obligation on his part.
Mr. Chair, just to help you with that, if you read on our information we received, it says 4755 Bennett Road as his residence. We did verify that he owns that, so wouldn't the lien move to that?
It's already on that.
Yeah. I mean, it is going to be attached to some property, even though we would remove it from 337 Main Gate Road.
Yeah. Press release. Okay, so it's, I didn't know that, but he does own that property now on Bennett Road.
We verified it while we were waiting for you.
Yeah, and so we should then make sure that we get the lien recorded there. But,
That's,
My question is, this gentleman, and I should know the answer, but I don't. Court-appointed attorney liens on property. If the on a contract for deed property and the contract for deeder forecloses, does the county lien go away?
No.
I don't think so either, so I agree. It stays on the property.
Yeah. It's.
Otherwise, that'd be a pretty sneaky way to get rid of all of them.
Yeah. Yep, it follows the person around, but once it attaches to a piece of property, it stays there until it's paid or the county commissioners release it.
Any other questions for Patrick?
so, Mr. Chair, I would move to release the lien on 337 Main Gate Road and transfer it to 4755 Bennett Road in Rapid City.
Is there a second?
Second.
We have a motion and a second. Patrick, did you hear the motion?
Yes.
Are you comfortable with that?
Yeah, if he owns the property on Bennett Road, really it's just a matter of making sure the auditor does the paperwork.
And you verified that.
Okay, thank you, Patrick. Okay, we have a motion and a second. Any further discussion? Do you want to tell us not to do it?
No, I want you.
Okay. There's no further discussion. All in favor of the motion, say aye.
Aye.
Opposed?
Aye.
Motion carried. Wait. Roll call?
No, it's up to you. I think it was 2-2.
Did we have some no votes?
2.
Yeah. Okay, so let's do a roll call.
No.
Davis,
No.
Holloway,
Yes.
Troutman,
Yes.
Peterson,
Yes.
Rick,
Look at these small.
Motion carried.
I don't understand.
Okay. Item 16. Request for authorization to construct a second approach.
Yeah.
Hi, I'm Dale Erickson. Good morning. I would like to get another approach to my property on Nemo Road.
I just have a question, Mr. Chairman. I've read through this, and if the one access that you have now is virtually unusable, I take it that you would have no problem in discontinuing that one and using the other one.
Excuse me. Yes, it's a blacktop approach. I hate to abandon it. It's a very nice approach from one direction.
Okay, I understand if it's blacktop, I guess.
Okay, any other questions for Mr. Erickson?
I have a question for our state's attorney. Or his assistant. We have an ordinance 14 that sets out certain responsibilities and things that we need to follow. We have the authority to vary the provisions of ordinance 14.
I would have to review that briefly, but I can step over to the auditor's office and do that.
I wish you would, please.
Certainly will.
We aren't, we're not the administration in Washington that can do, follow whatever laws they want and disregard the rest of them, but I would like to know the answer to that.
I'll be back in a minute or two.
Thank you, Mr. Buskird, for that statement.
Okay, so do you want to move this down?
I would like to, just to find out, I frankly would have no problem granting it for safety reasons, if we can, but I hate to just.
Okay, if you don't mind, Mr. Erickson, we'll postpone this until Patrick gets back.
Thank you.
And in the meantime,
Actually, there's
move on to item 17. And
Looks like I brought my lunch. I'm Jack Brott, and I think everyone knows.
Mr. Chair, I may be able to hurry this up considerably. How much time do you need?
Well, sir, it's kind of a twofold thing. I have no idea how long the Forest Service is going to dilly-dally with this thing. The letter that they sent to you all, I haven't a clue. If they follow through on what they're talking about and everything went according to their schedule that they had, we'd be looking at about another 60 days. However, the cheese is a little more binding than that, and basically what's happening to us is that if we apparently don't fulfill the terms of this CUP, then we're back to where we were a year ago, where we're out of business, and we're getting inquiries right now for the 2014 season. And with everything in limbo as it is, we're in a position where we're not able to book business. Now, we just went through the worst year that we've ever had in 36 years of doing business in Pennington County, and the reason is because of the fact that we were shut down. And we did about 40% according to our numbers right now as to what we would normally do. And we don't want to be, back into that position again where we're out of business until somebody decides that they're either going to give us a permit or not. What I have here, this isn't a crying towel, and you can see it's pretty well worn. And basically what it is because of the fact of the frustrations that we've been put through because of this issue. It's not just with the Forest Service either. If it weren't for a lot of you who are sitting before me right now, we wouldn't be where we are right now. But, what really this is that if we have to go through another issue like we did this last year, we're ready to throw the towel in and say to hell with it. Because we cannot exist on doing 40% of what our normal business would be over a course of another year. We've had to really scrimp and get by with what we've done, this year in the business that we've had, and I don't want to repeat that. So what we need is some sort of authority from you guys to go ahead and to continue to operate our business. I have no idea how long the Forest Service is going to take. We've done everything that we can, including insult them, and it doesn't seem to have helped. Maybe the matter is that it's made matters worse. The other part, we have done all of the issues on the CUP except the one with the Forest Service. And we're still waiting on Dan's department to give us a new 911 number. And we've been down there to his office multiple times, and every time we're told, well, we'll let you know. And so we have not been able to fulfill that part of it. So, but the Forest Service one, I'm sure, is the main culprit in this.
any other questions or comments? Dan, do you have some input?
Well, I did talk to the Forest Service, and they indicated that it would be about 60 days, as Jack had mentioned, before they can get an answer back. And that is my recommendation, that we just continue this for 60 days, probably the first meeting in November, to wait for an answer from the Forest Service. And that's what they indicated. They have to wait for some comments to come back. If somebody doesn't appeal it, then they have to wait before they can grant that access.
I guess I would not go along with 60 days because my experience has been that it always takes more than what they think, simply because it's very difficult to get through the process in DC.
Mr. Chairman.
Yes, ma'am. And then we got one more thing that we want to consider. If you've been listening to the national news, you know, they're talking about the possibility of a government shutdown. And I can tell you from having lived through that with the Forest Service before, Lord only knows when in the world, because they'll certainly use that as an excuse not to get anything done. But we've got to have your permission to go ahead and continue to operate, or we're out of business. That's basically about where the position that we're in.
The worst that'll happen, the way I see it is, we can, even if they deny him, the worst that's going to happen is a year from now, we'll review the conditional use permit again. So today we would be actually giving him permission to stay open for another year. And that'd be my motion.
Second.
Okay, we have a motion and a second. Any further discussion?
For 12 months?
Well, hopefully he gets permission and then everything is settled, but if not, we'll look at it again next year.
Otherwise, the 1 year comes up when we
Okay,
approve.
so let's help our secretary a little bit with,
If I can add a little bit. The CUP was that it was approved back in May 28th. And one of the conditions is that it's reviewed a year from that approval date. So in May, it will be reviewed again.
But that could shut him down right in the middle of
Yeah,
his
it's
turf
going to shut us
season.
down after we've already booked a bunch of business. That isn't going to work.
I don't think that would.
You know, that we've got to be able to plan on operating the whole 2014 season, or we might just as well forget it.
And you've complied with all of these except number 9?
I'm sorry.
You've complied with all of these conditions other than 9?
Let me get my.
He said he was looking.
Number 9 is regarding the access from the Forest Service.
Oh.
So what's the goal if the Forest Service says he can't, they're not going to allow this? Then what's the goal? What's his options then?
I can't foresee the Forest Service denying it, and they basically have said they're going to grant it. It's just a matter of waiting for the appeal period to go through, and then they'll grant the access.
Okay.
This is a sheet, I know that some of you probably have already seen it, but what it is the regulations that the Forest Service is supposed to be following that says that they have to provide access to people like ourselves. And, you know, how long are they going to mess around with it, I don't know. According to the regulations that they have to grant us the permission. But I just don't see where we have to be put out of business because we're messing around on waiting for them to do something. Because that's what'll happen if we can't continue to operate.
My intent, Mr. Chairman, was to let him operate through the next summer for sure.
Yeah.
1 year from today's date. That's my, yeah.
Hardly fair to do it any other way.
That's part of your motion, and I'll second that one.
okay,
Part of my second.
we have a motion and a second. Any further discussion?
And the motion is that we're going to approve this conditional use permit excluding number 12, or excluding number 9 for 1 year. Is that the motion, or?
And be reviewed in 1 year.
From today.
From today.
But we're not going to require him to comply with number 9. We want, encourage him to go ahead and get it, but I'm just trying to figure out what we're voting
I
on.
think that's,
That's important, yes. And I guess I would recommend November 1st of 2014 as the
That's fine, too.
as the anniversary.
I would appreciate that because our regular operating on our outfitter guide permit goes through the month of October. So if we could do it, you know,
November 1st.
at least at the end of October or something like that.
Well, do you not want it to be reviewed then? Because we'd be reviewing it in regards to all the other conditions to come that meeting in May. Then I would just put into that staff report that county board has made a motion to continue this to November 1st. Because this normally just goes to planning commission and not even to county board. Because it is a conditional use permit.
I won't have a problem with that.
I can still do that. Okay.
And
I just don't want Jack to be surprised when he gets a call from us saying we're reviewing it in May, and then he comes back and says, well, county board said you're not supposed to review it until November. But, so I just want to.
part of your review is going to be that you're going to continue the review.
Exactly.
Until November 1st.
Okay, are we clear?
I am.
Mr.
The
Chairman,
action
could
we're
you,
taking will be November 1, 2014. Any further discussion? If not, those in favor of the motion say aye.
Aye.
Opposed, motion carried.
Mr. Chairman,
Yes.
I'd like to back up to 16 on this second approach. I reviewed, and so did our state's attorney, ordinance 14, and one of the provisions says, to reserve to the Board of Commissioners the full authority and discretion to exercise its best judgment to resolve problems that are unforeseeable in this ordinance. I think that probably gives us the right to allow a second approach. And since Don already gave his big spiel and made a motion, I'm going to make a motion too, that we grant the second approach to this property based really upon safety.
Second.
Am I correct that you made remarks before the motion?
I did, but see, there has been a precedent that happened before in this meeting.
I see.
I'm basing mine based on that precedent.
It'd take an attorney to pick up on that, wouldn't it?
I don't care.
Okay, do we have a second to the motion?
I did, yep.
Commissioner Davis seconded the motion. I would, my recollection is that we've done this before.
Yeah, I think so.
Either that or I can make the first.
And unless someone has any objection, is there anyone who wishes to comment further? We do have a motion and a second. All in favor say aye.
Aye.
Opposed? Motion carried. You have your driveway permission.
Thank you, Commissioners.
Okay, we are now at item 18, request for waiver of penalty fees. Do we?
The applicant, or this is in regards to a variance that will be heard today also. Julie Jensen is requesting to waive the doubled application fee plus $500 penalty fee. And it's to bring into compliance a detached garage that was built on the property prior to her buying the property by the former owner. And then she's also requesting to waive building permit fees on this structure that was built without a building permit and another structure that was discovered to have been built on the property without a building permit also. Those fees are normally double the fee. Those amounts are on the memo that you have before you. The variance application is a total of $800 that they're requesting to waive, and the penalty fees for the building permits is totaling $269. And that is her request. The building permits were supposed to have been obtained by the former owner. She will be required to get those building permits now in order to bring the property into compliance.
Mr. Chair, I'd make a motion to waive the penalty fees for Julie and Gary Jensen.
Is there a second? I'll second it, so we can discuss it further.
In response to Commissioner Busker's earlier comment, we do have a precedence where we have done this because the current owner is being penalized for what the previous owner did not do. And as long as they get the building permits and bring it into compliance,
Thank you. Mr. Chairman, and you are correct, we have done it before, and you're also, I have voted against it every time, and I intend to vote against it this time, because it's not our problem. It's not our problem. If they don't like it, they can take them to court and sue them for that amount of money, misrepresentation or whatever. It's not the rest of the taxpayers in the county's problem.
Any further discussion?
Mr. Chair,
Yes.
I haven't made up my mind until the final straw is dropped that whether I'm going to vote for or against this. But I am with Mr. Buskerud on this, that it's time. I believe in your purchase and sales agreements through real estate agents that things like this are supposed to be disclosed. And if you build something on the property without a building permit, I think that's a misrepresentation of the purchase and sales agreement. So I believe Mr. Buskerud got it right on the head. Maybe it's time to sue somebody and get that straightened out.
Mr. Chair?
Yes.
Dan, do you know when the RV garage and the other building was actually built? How long ago?
Well, it was after 94 and before 2004. And any time between then does require a building permit. Even before 1994 required a building permit. However, because the ordinance was thrown out, it was built prior to that date, it's grandfathered in. So it was built sometime after 1994.
In the same way with the side yard setback, or the setback, 25-foot setback requirement?
Yeah, the setback has always been 25 feet in a low-density residential zoning district. It's always been that. So the structure is only 2.5 feet from the property line.
Oh, it's only 2.5 feet?
Yes.
Holy.
what's on the other side of that property line, though?
The nearest house is like 250 feet away.
50 feet,
What, how do you know that the structure was built between those dates that you stated?
Well, we also have aerial photographs, some that are dated 1997, so I believe it was probably after 1997, because in that photograph it's not there, and then now it is. So the aerial photograph in 1997 does not have it on the photograph.
This almost strikes me in a way, penalizing someone who was not a party to the violation. It strikes me that it's almost like the lien deal we just got through working with. And I don't know how many times we've dealt with this, but seems like more than once, and it strikes me that it's a factor that's worthy of consideration and examination to determine what is the appropriate and fair thing to do through ordinance or otherwise. Because, to get penalized for something that you had no party to, maybe your great-great-grandfather did something and then you end up being persecuted for what he did, it just strikes me as we're off base when we do that. And that's not your fault, but in terms of going after an innocent party for penalties and so on, doesn't strike me right.
Mr. Chair? Yes. I guess then a question to you is, do you think our ordinance, the way it's written then, would give us the legal right to go after Jerry Wrightstrom, who was the owner, for these penalties?
Well, if you're asking for a legal opinion, I can't give you one, but as far as I'm concerned, if you're going after somebody, it ought to be that person.
Well, I see our studious state's attorneys back there. Can we go after the former owner for these penalties?
For the penalty fees in the ordinance?
Yeah.
No, because that's just tacked on to the price of the permit or the variance that you need at the time. We can go after them criminally in magistrate court. Typically, we haven't done that because lots of times, tracking them down can be difficult, and if they've left the county, we can no longer charge them with an ordinance violation because I can only serve a summons for an ordinance violation within Pennington County. Typically in ordinance enforcement, my primary goal is to bring the property into compliance, and the person who has the ability to do that now is the current landowner. So that's the person that I go after legally.
But why do you go after them rather than working out a deal to get it in compliance and then go forward?
Well, and when I talk about what I do, I get a file after the planning department has tried to get in touch with the person and tried to work something out and had no success. So typically when I get a file on something like this, I haven't gotten this file yet, but when I get a file on something like this, I look through and I'll find 3 or 4 letters and maybe phone calls from the planning department, and the person simply has never come in and gotten their permit or never come in and gotten their variance. So the planning department has tried to work with the person and it hasn't been successful. But when I actually charge out an ordinance violation on a property like this is a building permit, right?
And a variance.
And a variance. So when I would get a file like this, the planning department has already tried to work things out and haven't been able to. But I go after the current landowner. That's who I charge in magistrate court, because that's the person currently who can get a building permit and can get the variance because they're the current property owner. Our ordinance would allow me to go back in time if I can track down the person 1 or 2 or 3 or 5 property owners back who created the problem, and it's within 7 years. Our ordinance would allow me to go back and go after that person. The reason I tend not to do that is, first of all, I can't always track the person down, and if I do, they might be living in Cottington County now, and I can't serve them with a summons on a Pennington County ordinance violation. But more fundamentally, my goal in enforcing ordinances is always to try to bring the property into compliance. And at the time I have the file, the person who can bring the property into compliance is the current property owner, and they're the person who hasn't done so at this point. So that's who I charge with an ordinance violation in court. At this point, we're just looking at waiving the late fees that a person has to pay, that the property owner has to pay to get the building permit now. I don't think there's a way in our ordinance for us to go back and collect the penalty fees from the previous owner.
There is not. Because in all that discussion you were just going through, I got the impression you could, but then it doesn't sound like you can.
There's 2 penalties that go along with building a shed without a permit. One is to bring the property into compliance.
I understand bringing it into compliance.
Right.
What I'm trying to figure out is, can we go back after the former owner? If the former owner is still in Pennington County, can we go after them for the penalties? Because I agree with the chairman. It seems crazy to put a fine on somebody.
Yeah.
Because that's what this is, put a fine on somebody who had nothing to do with the problem.
Yeah, you cannot go back and collect the penalty fees that you're talking about today on this property from the former owner, because that's just a question of how much the building permit cost. And our ordinance doesn't allow you to go back and say, okay, to get that building permit now, the current property owner has to pay half the building permit or a third of the building permit, and the guy who owned the property 5 years ago, who we think created the problem, has to pay the other 2/3 of the building permit. We don't have a way of doing that. Our ordinance doesn't allow it.
Okay.
So I'm sorry.
Go ahead.
I think we ought to, Dan, I think you should work with Patrick in coming up with an amendment to our ordinance that would allow us to go after the previous owner for these penalties. Now, I agree if the current owner is the one that created the problem, then we ought to penalize them. But if it was created by someone else, then we ought to go after that person. Frankly, I don't think when you do a title search, it's going to show this up because you weren't even aware of it until they came in for a new building permit or some.
That brings up an interesting point is right now, when they do a title search, they're not required to check with planning and zoning to make sure they have all their required permits.
Would have you known if they'd have called you and said, is there any outstanding building permits issues with this property?
Only if they showed us what's on the property at this time.
I see.
But isn't there, I mean, when they built it, I assume the equalization went out and we're taxing them, or are we not even taxing them?
That I haven't checked yet, if they're taxing it or not, but a lot of times equalization doesn't go out for 5 to 7 years.
They slide on that too, and that's the current owner.
Any further discussion?
Do we know if we don't know if they're paying taxes on those buildings now?
I myself have not checked. Lisanne is the one who did the memo, but I'm not sure if they're paying taxes on that. But after they get the building permit, they for sure will be paying taxes on it.
Mr. Hensley will shortly be telling us.
I'm not sure he can tell us with his full.
Gene Hensley, and I represent Mr. and Mrs. Jensen. And I hope that in this file we have something from the Director of Equalization that will show us. Did you see it? Yeah, but it doesn't show up.
While he's looking for that, if I understood Commissioner Holloway correctly, he was suggesting that amendments to our county ordinance should be considered to correct this situation, or not this specific one, but to avoid it in the future.
That's correct. I mean, I agree with you. It doesn't seem right that you fine somebody or penalize somebody for somebody else's actions. And granted, what we're trying to do is get the property into compliance, and that's what the new owner is trying to do. But when we can, we should be trying to go after that previous owner.
If I could, just a couple of comments. Mr. and Mrs. Jensen bought this property without a real estate agent in 2004, and they bought it in good faith, and Mrs. Ridstrom sold them the property and did not tell them that they did not get any building permits. So, and of course, the title work did not show anything that there were any encroachments or there were no building permits. Now, Mr. and Mrs. Jensen have sold this property, and we're trying to bring it into compliance, and we're working with the planning department, and it's been rather extensive, and they've been very helpful. We've had the property surveyed at an expense of about $300 to show the encroachment of the utility, or the RV garage. And when we did that, we showed the studio on there, and now we have found that there's two buildings that do not have building permits. And we are going to go ahead and get those building permits and get this property cleaned up. But as some of the commissioners feel, I don't feel that this is Mr. and Mrs. Jensen's violation of the ordinance to give the building permit. So now you're going to penalize somebody that really didn't know anything about it. I agree wholeheartedly that maybe Mrs. Ridstrom should be up here writing the check, and Mr. and Mrs. Jensen are going to clean this up, and so you won't have that problem in the future.
So so Jensen's owned it since 2004?
Correct.
Have they been paying taxes on those two buildings?
Mr. Holloway, I can't tell if it's on the Director of Equalization, but they're paying $8,300 $1,000 a year in taxes, so.
Well, if they haven't been paying taxes on those two buildings, then this is probably cheaper than paying the taxes on it in the last.
And the other thing, of course, is that the original owners who built up the buildings, they maybe didn't know they needed a building permit. That's entirely possible, too. But we are gonna go back and penalize them because they didn't know. Well, what's the difference? I guess, I don't know.
Well.
Yeah, but if you don't know what the speed limit is and you get a ticket, you're still gonna pay the fine.
And you shouldn't buy property by yourself. That's the other lesson.
Okay, any further discussion? If not, let's have a roll call vote.
What's the
What's the
motion?
motion?
Yeah. Okay.
They'll
Mr. Chair,
pay for the building permits, but no.
I believe somebody mentioned that they found another building that didn't have a building permit. Is that included in this?
Yes.
Okay, so it's all taken care of then, all right.
No.
How come you always call them this alphabetical order? Yes.
Sometimes you go backwards. You start at the bottom and you go the other way.
Holloway,
Yes.
Troutman,
Yes.
Peterson.
Yes.
I think it says in Robert's Rules of Order, you're supposed to do them in, so that's.
I thought that was Karen's rules of order.
You can waive that too, you know.
Okay, the motion carried. And we're now on item 19, the building permit fee Independence Hall project. Dan?
This is in regards to a request from Don Purdue, who got a building permit to build Independence Hall just on the other side of Reptile Gardens. Our current ordinance says that it's 1% of the construction cost, which came to $17,000 for the building permit. He's now requesting, or has requested, to waive a portion of that fee. I did wrote this to our state's attorney's office. He indicated with our current ordinance, this does not allow for us to waive a portion of the fee at this time. However, we could do an ordinance amendment that would change that and allow for the county board
So
to.
why would, just out of curiosity, did the owner not have any idea that they would be required to have this when they began their process of planning to put the building up? And, I mean, did they not know? Why would, it seems like if you were planning to put in a building and do all of that, that you would have checked to see how much it cost before you went that far down the road.
Mr. Chair, if I might. I think the gentleman was well aware of what it was going to cost him, and I think planning and zoning probably told him that. But I think it was just a little bit of burr under his saddle to pay a $17,000 building permit fee. And basically, we don't give anything for it. We don't send anybody out to inspect anything. If we go out and inspect septic systems, we charge them extra for the septic system. So he thought it was a little absorbent just for a $17,000 fee and not do anything other than just write the paper. And the next thing that I thought is not really the thing to do is that only $60 of this went to the planning department, and the other $16,940 went to highway for drainage. And so I think maybe we ought to look at changing this all the way around a little bit, and with planning department getting $17,000 and all they do is wind up getting 60 of it. Maybe we should look at that too, to put a little more revenue into their department.
Any other discussion?
Just out of curiosity, that drainage fee, is that connected to some kind of state law that we have to charge it, or is it just our?
It is our ordinance.
Probably it. That part, I definitely agree with you. We should look at that, but I think that it's a cost of doing business, and certainly if he was in the city limits, he'd be looking at a pretty hefty price too.
I think Dan looked that up too, didn't you, Dan? Or didn't you find out what that would be in the city? Of course, they have full inspections, electrical, plumbing, building, everything, so.
Yeah, the normal fee would have been $7,800, but that did not include inspection fees. And if they're building in the downtown area, it all depends on a number of different factors. And what I understood, it could be upwards of $25,000 to $40,000 for the building permit fee.
But
It all
7,800
depends.
is what their fee is without inspections. Well, we don't do inspections,
No.
so maybe we are high.
Yeah, and I did put a possibility that we put a cap on the fee, not to exceed a certain amount. And the opinion or the example is $10,000. That would be the maximum building permit fee we could charge if you agree to that we put a cap on the fee.
But I don't agree to changing an ordinance to satisfy one person.
Well, if I,
Well, this would be anybody that applied for.
I agree, but we would be changing this ordinance based on a request from
Yeah.
one individual, and I would rather have an ordinance change reviewed and look at different possibilities and compare us to.
well, if I have interpreted this correctly, initially, Mr. Perdue requested us to discuss the a fee change.
Yep.
He didn't ask for a refund or anything else. And then the next step was the motion to have you research this, which you've done and have brought it forward. So in order to proceed in any fashion, there would have to be a draft ordinance processed with a first and second reading and all that sort of thing, right?
Yes. We have to do an ordinance amendment to
Would,
change the fee process.
has this been discussed with the planning commission?
No, is not.
So would that not be a proper process? So if we're going to take action on this today, in any fashion, it should be moving toward an ordinance draft or whatever.
Well, to forward it on to the planning commission for their discussion and possible ordinance amendment.
So what's your wish?
That'd be a good place to make a motion, that I'll do so. To
I'll second
send it to the planning commission.
Motion and a second to send this issue to the planning commission for consideration for an ordinance change.
And Mr. Chair?
Yes.
I think also, and I don't know if this would be okay with a second, but that part of this, we look at of the fee that's going to drainage rather than just planning and zoning. Look at all of that in one spot.
I agree too.
Okay. Any further discussion on this? If not, those in favor of the motion say aye.
Aye.
Opposed, motion carried.
Thank you.
Dan, you're on again.
Okay.
Item 20.
First, need a motion to go into Board of Adjustment.
So moved.
Second.
Moved and seconded to convene as the Board of Adjustment. All in favor say aye.
Aye.
Opposed, motion carried.
Item A is a variance request 1311, Julie Jensen, Gene Hensley as the agent, to reduce the minimum required side yard setback from 25 feet to 2.5 feet in a low-density residential district. Staff, if the county board approves this, we'd recommend that 2 conditions be attached. This is the one we just discussed in regards to waiving the fee. The property owner bought it without knowing the structures were built on it. Come to find out, before they can actually sell it, they need to clear up the violations, which is the encroachment for the shed that is 2.5 feet from the property line. Certainly appears that there are other areas they can build on the property that meet the required setbacks, but this is an existing structure. They would have to pick it up and move it or cut off about 22 feet of it in order to bring it into compliance. Not sure what else you want to discuss.
Dan, doesn't 2 kind of contradict number 1? It says this variance only applies to the portion of the side yard setback required to be encroached upon by the existing detached garage. And then 2 says about the studio and the garage. So shouldn't both of them be mentioned in item 1 also?
Well, the studio does not need a variance request. It meets their required setbacks.
The studio's way.
It's just the
Oh,
detached.
okay, so I thought the way that you explained a little earlier that both of them were in the setback.
No,
Okay,
just the one.
good enough by me.
Any other questions?
Well, I thought you said it was 20, it's front yard setback that we're dealing with, or side yard setback?
Well, this is a side yard setback, but all setbacks within a low-density residential district are required to be 25 feet.
Well, this shows here that the studio is 18.6.
186, I think it is.
Oh, it's 186. Okay.
But I have a question. And I have just the perfect person to ask. On the bottom of this, there is a plat with a registered land surveyor's seal, and it shows that the garage is plus or minus 5 feet from the lot line. Don't you ever, isn't part of your responsibility to say, you got a problem here? I mean,
I'd be happy to respond to that.
and it's just a question.
When we found out that the garage encroached, we
Then you
did have a problem. But you need to remember that when Mr. and Mrs. Jensen bought the property, they bought it from the owner, so Mrs. Ridstrom didn't stand up and say, hey, you got a problem with this.
And the survey was done after, I see it was done in 13, so,
Yeah.
okay.
That answer your question? Thank you.
Any other questions or comments? Do we have a motion?
Still is. Let's see.
So, Mr. Chair, I would move to grant the variance with the 2 conditions.
Is there a second?
Second.
Motion and a second. Any further discussion?
Since I'm in such a good mood today, I think I'll vote yes on this variance.
That's good.
You want to take a break and rethink this? or-
You want a roll call vote too?
No.
All in favor of the motion, say aye.
Aye.
Opposed? Motion carried. Item B.
Item B is a variance request 13-12, Carol Navikis, Davis Engineering as the agent, to reduce the minimum required setbacks from 25 feet to 15 feet from the northwest property line and to 0 feet from the section line right-of-way. If County Board recommends approval, we'd suggest that one condition be attached. It's located at 22774 Merritt School Road, east of Highway 385, and involves 8.69 acres. Property currently is zoned general ag, which requires usually a 40-acre minimum lot size. However, this is a mining claim that was created back in the 1800s, so it is a legal non-conforming lot as far as lot size. This structure has not been built. It is their preferred location to build this structure in that location. The section line is very close. They're not building in the right-of-way, but just adjacent to it is what they're requesting. The Forest Service did comment that they're also putting up some retaining walls, and the retaining wall originally was proposed to be 0 feet from the property line next to the Forest Service, and they had indicated that they would like at least 2 feet. I understand Mr. Davis has talked to the Forest Service, and the Forest Service, which I have not confirmed, agreed to a 2.5-foot setback. It certainly appears that they could build elsewhere on the property that would meet the required setbacks. They've done some extensive excavation on the property to build the house, and then they would also have to do some even where they build the garage. But it certainly appears that they could meet the setbacks by building somewhere else on the property. It is, to also comment, it is 100% surrounded by Forest Service land.
Dan, in terms of the Forest Service and the section line, I may have the wrong perception, but if the wall is going to be, or the structure is going to be on the edge of the section line right away, which is what, 66 feet?
Yeah, 33 feet on either side of the
Yeah.
section line itself is the setback and, or the right-of-way. And then the county has an additional 25-foot setback. So actually, they are required by ordinance to be 58 feet from the section line.
But in case of the 33 feet of the section line that's on the private property owner's side, where is the wall going to be? Is it going to be next to that center line or next to the 33-foot line?
It's actually going to be next to it, around it, and also in the section line right-of-way. But we don't regulate retaining walls in our ordinance. The section line is currently unbuilt. This section, or this variance, is for the structure and not the retaining wall.
But, so it goes around here?
Yeah, that double line you see on that site plan is the retaining wall. You can see it going into the right-of-way adjacent to that northeast property line, going straight east and west, and then along the northwest property line, and then comes down and goes towards their driveway, along their driveway to the proposed garage area. What I understand, this is gonna be like a horse barn, and he has a horse trailer, and that's why he wants to come around and be able to come into the parking area you can see in front of the garage, and then back onto the driveway.
I understood that this is surrounded by Forest Service on all sides.
Correct.
Okay. And there isn't anything else that'll be harmed by this action?
So with the way this is set up, though, that section line's never gonna be accessible. So maybe it should be.
I can't say never, because that's a hard thing to say, but it is a very steep topography. More than likely, a road would never be built in that area, but I can't say that. It is set up as, of course, section lines are public right-of-way. It certainly could be, utilities go through there, power lines, but at this time, there is no utilities going through this right-of-way.
Mr. Chair?
Yes.
I'd make a motion to approve item B, variance 13-12 for Farrell and Vicus as requested by the applicant, with the one suggestion by the planning department that's so entered here.
Is there a second?
Second.
Motion and a second. Any further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Did you vote?
I did, I
He
voted
did, he
yes.
was, yes.
You still in a good mood?
Twice. If it wasn't on TV, I'd tell you.
Mr. Chair,
Now we need a motion to come out of the,
that's what I'm gonna do. I'll make a motion to come out.
motion to adjourn the Board of Adjustment. Is there a second? Any discussion? All in favor, say aye.
Aye.
Opposed? Motion carried.
Mr. Chair, I would make a motion that we take a 10-minute comfort break.
I already did, that's why I'm in a good mood.
Is there a second?
Thank you.
I believe the next three items would go very quickly if you wanted to get through those.
Who asked you? Okay.
What's your wish?
Now,
Okay, what do we do?
Okay,
Okay.
proceed.
Well, the Board of Commissioners uses the consent agenda to act on non-controversial and routine planning and zoning items quickly. The consent agenda is acted upon by one motion of the vote of the board. Items may be removed from the consent agenda and placed on the regular agenda at the request of the board member or a citizen. The consent agenda for planning and zoning contains the following items. Item C, first reading and a public hearing of rezoning 1315 and comprehensive plan amendment 1309 for Neil Tschetter. It is to be continued to the November 8th meeting. Item D is the first reading and a public hearing of rezoning 1313 and comprehensive plan amendment 1307 for Mitch Morris, and that is to be continued also to the November 8th meeting.
Does anyone wish any items removed from the consent agenda? If not, do we have a motion?
Move to approve the consent agenda for planning and zoning as presented.
Second.
Motion and a second. Any discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried.
Item E is the first reading and a public hearing of rezoning 1314 and comprehensive amendment 1308 for Mitch Morris. The applicant has called me this morning and indicated he could not attend this meeting. He is out of town and requested that it be continued to the October 1st County Board meeting.
That's my motion.
Second.
Motion and a second to postpone item E.
Mr. Chair, may I make, I'm not willing to continue it after October 1st because we continued and there's just a lot going on. So I would like to make that statement. I'll go with it this time, but I think we need to make a decision sooner or later on this.
We may want to notify him of that.
I will do that.
With that, do we have any further remarks? If not, those in favor of the motion say aye.
Aye.
Opposed? Motion carried.
Thank you.
Now you want to take your break?
Yes. 10-minute break. I'm going to take one, whether you want it or not.
All right, we will declare ourselves in recess. We have,
Former Commissioner Chapman, how are you?
you need a motion,
Yep.
so that's your motion. Who seconded?
I did.
All in favor?
Aye.
Carried. Second?
Second.
Motion and a second to reconvene. All in favor, say aye.
Aye.
Opposed? Motion carried.
Good morning, Brittany Molitor, Water Protection Coordinator. I'm presenting item F, the Spring Creek Watershed Management Project Implementation Plan Advisory Group Recommendations. I'm just presenting these today. There's no action that can be taken at this time. So on September 11th, 2013, the Spring Creek Watershed Management Project Implementation Plan Advisory Group made 3 recommendations to the Pennington County Board of Commissioners. Those recommendations include that the Pennington County Board of Commissioners approve 2 riparian applications, SPC 2013 PC 98A and SPC 2013 PC 105, and 2 on-site wastewater treatment applications, SPC 2013 PC 98B and SPC 2013 PC 101B, and allows the applications that are not funded to remain pending and to be considered with the next round of applications. The second recommendation was that the Pennington County Board of Commissioners allows continuous cost share application submittals for Segment 2. The advisory group would meet at least twice per year, but not more than quarterly, to consider the applications and make recommendations to the Board of Commissioners. The third recommendation was that the Pennington County Board of Commissioners approves the Spring Creek Watershed Management and Project Implementation Plan Segment 2 amendment and submits it to the South Dakota Department of Environment and Natural Resources. So I'm just presenting those recommendations today, and I guess my requested motion is that it get put on the October 1st meeting agenda for consideration. And
I'll make that motion.
Second. Nope, go ahead.
Motion and a second to place the Spring Creek Advisory Committee recommendations on the October 1st commission meeting schedule. Is that?
yes, for consideration to take action, vote on the recommendations.
Mr. Chairman.
Yes.
And at that time, we'll have more information as to what the PC 105 is all about, other than just an amount?
Yes. DENR will also be here at that time, and the other project coordinator will be here.
Great, thanks.
Any other questions or comments? If not, we do have a motion and a second. All in favor, say aye.
Aye.
Opposed? Motion carried.
Thank you.
Items from the chair, I don't have anything except to report that there was a communication from United States Department of Forestry asking whether or not there was a need for a program that would permit outfitters to use the national grasslands in a similar manner to to them permitting outfitters to use wilderness areas and Black Hill, or, Forest Service land. And it was simply a question of do we or do we not think there's a need for it. And the outfitters are required to meet qualifications in terms of their equipment, the way they handle their animals, like if they're taking a group out horseback, what they can, the kind of grazing they can do. You can't haul hay in, different things like that. And not a burning issue by any means, but they are asking opinions. So at some future point, we might look at it. But that's all I have. Do we have committee reports?
Mr. Chair, I have one from the Air Force, and that they just told us yesterday at a meeting that we had that the base in North Dakota where the B-52s are housed is having runway refurbishing, and so some of their B-52s are hanging out here at Ellsworth while that's happening. And that's about it.
I was at the annual convention of county commissioners in Spearfish Sunday through Wednesday. I got some information on what resolutions they're going to forward to the legislature this year, and there aren't many of them. And I'll supply that to Holly, who can put them in your folder for your perusal at your leisure.
Thank you. Commissioner Holloway?
I don't believe so.
Well, I did attend a couple of the days of the state convention, and one of the things that was probably most noteworthy is that Scott Guffey was awarded the Outstanding Service Award for Employees and for his work in Mountain Pine Beetle. That was wonderful to have him. And I think we are going to recognize him and the safety awards next year. I just think it was great that Scott was able to get that.
And very nice of you to nominate him.
Well, he deserved it.
Yep, he did.
Anything further? You're doing a lot of work on the ag tax thing, and continue to meet
yeah.
on Wednesdays.
Yes, at least for this next week or so, we've done the research. We're kind of in that time period where there are some things that we've discussed about how the process could work on a countywide process at equalization, let alone some definitions. And we're looking at the probability that equalization office will come back with some ideas next week, and we meet every Wednesday at 9 o'clock at the extension office. And it also has some of the thoughts that we had for the confusion in the law have been passed on through some of the legislators to the Legislative Research Council. They are looking at that. They're hoping to have a report back to us around the 1st of October. So we're kind of in a hold right now until we can see what those two aspects come back to us as.
You've reminded me that I was at the RC&D meeting, and Dave Hazeltine from Custer County, he said he may, I don't think he can come to the next meeting, but possibly the following one. But he said, we are very interested in what you're doing in Pennington County.
I spent a lot of time talking to other county commissioners where actually there is just such an extreme variety of how that law is interpreted. It's pretty amazing.
Well, I think it's very commendable, the effort that the citizens are making. And
They've done a great job.
anything else?
That's it.
Okay, items from the public. Anyone from the public who wishes to address the commission?
I'm George Farabee, and with your permission, I do have a couple of comments. And speaking of the RC&D meeting, I was hoping Lindell would pass on to you folks that next Thursday night, from 6 to 8 in Keystone Community Center, there'll be a briefing on the Battle Creek TMDL that's in the works. You're all familiar with Spring Creek, of course, and Battle Creek is next on the list. I reviewed the TMDL document, the one for bacteria. They have one in the middle for temperature. And yes, I said temperature. And that would be the primary focus Thursday night in Keystone, is the contractor will be briefing on the temperature TMDL for Battle Creek. I might also mention that Custer County, the representative at the RC&D meeting, said that Custer County is going to lay low. I believe that was a pretty good impression of what Hazeltine said. Was that correct, Lindell? They're not going to get involved, in other words, until somebody asks them to get involved.
Well, yeah, they recognize that this is very preliminary.
And most of Battle Creek is in Custer County. Anyway, meeting is, like I say, 6 to 8, and I understand the gal from EPA that will probably be doing the blessing or non-blessing of this document will be in attendance. Other item, some time ago, there was a comment made that about Spring Creek projects, and Don Holloway asked very pointedly to the watershed scientist that was standing up here, and I know we've been through this before, but I do have a letter now. Anyway, Don, as I recall, his exact words to this watershed scientist were, "You will not or you can't disclose the details of the project." And the words were, "cannot because written agreements, signed agreements with NRCS." I don't know who is telling a story. All I know is there's a conflict. And Don, if you would, I'd like you to read paragraph 2 for the Public Commission.
Oh, if you want it read, you read it.
I had previously told you folks that the letter was on the way, and since then there's been the other meetings have been busy, so I haven't brought to your attention. But second paragraph, and this is signed by the state conservationist for NRCS. United States Department of Agriculture Natural Resources Conservation Service has no, repeat, no specific written agreements, contracts, or MOUs, memorandum of understanding, related to the Spring Creek 319 watershed project with any of the project sponsors, their contractors, or their consultants. So either this person is not telling the truth, or the person that got up here in response to Don Holloway is not telling the truth. I'm not going to make a judgment of which one. I have a pretty good speculation of who's telling a story.
Would you read that again, please?
United States Department of Agriculture Natural Resources Conservation Service has no specific written agreements, contracts, or memorandum of understanding, MOUs, related to the Spring Creek 319 watershed project with any of the project sponsors, that means you folks, their contractors, or their consultants.
but it does not say individual private citizen landowners who may enter into agreements with USDA. It does not say that. Thank you.
And thanks for bringing that up, and that opens up the question is of confidentiality by NRCS rules, okay? So the watershed scientist got up here and said the reason that he couldn't tell Don Holloway, answer Don Holloway's question about the details of the project was because of NRCS rules. NRCS rules don't apply. This is not an NRCS project. The NRCS rules, and Lindell, you and I can debate the NRCS rules. And when I read the handout or the codified, the CFR, Code of Federal Regulations that talks about NRCS, it's totally within USDA. Once you step out of USDA hands, the confidentiality doesn't apply. So I understand where you're going. But these projects aren't USDA projects. And if you read USDA rules, the confidentiality rules, it's totally within house. So RESPEC couldn't see them either. Anyway, Don, I appreciate you pushing the point. The confidentiality thing is just crazy. But here we're going to have another 2 offerings on riparian projects and no details. I was at the Spring Creek Advisory Group meeting last week. No details of the projects. The only question the advisory group asked, the common theme was, do we have money left in that pot? There was no discussion of merits of the projects. 0 discussion of merits. It's only, do we have some money to spend? Didn't talk about that under that item because that wasn't open for the public discussion. Once again, Don, thanks, and this fella, this new state conservationist, I've talked to him several times on the phone. He seems to be really an aggressive kind of guy, and anyway, I'll leave it at that. One other quick thing, I feel so sorry for the folks that nature's taken it out on in Colorado, and as that happens, you know, a person reflects back on things that happened in my lifetime, like 49. The whole winter of 49 was horrible. And blizzards were, you know, a part of that, obviously, and the recent flooding, you know, 2 years ago in the Missouri let go, and nature let go on the Missouri, I'll put it that way, and of course, 72 Rapid City flood. But the one thing that I, you know, as you think of these things, you think of, I can still see the Hilux jug sitting, I think it was right there where Don Holloway's sitting, and I think, Ron, you were over here 11 years ago, and Dolores Coughing brought that jug up and put some dye in it. Remember that, Ken? She put some dye in that. And she said, I dared to get that out. And what she was referring to was contamination, contaminating the aquifers or the waterway, the water bodies. All these folks, for the last, almost 2 weeks now in the Boulder, Colorado area, probably equivalent to half the population of Pennington County or more, but they quit going potty. Or there's treatment plants. Where does all that stuff go? But here's Dolores Coughing saying, dang, I'm up on a hill and I can't go potty because without whatever, because it might contaminate it and you'll never get it out. That's not the way nature works. But those things make you reflect on how puny we are. I tell people I go potty up in the creek every day and you never know the difference. You know? So what are we trying to? We're trying to fix the world, and man's too puny. But that Hilux jug, you know, things will stick out in some people's minds forever, and that one will be one of them. Ron, you were over here, right? I forget exactly where Ken was sitting, but you remember the Hilux jug, don't you? Both of you guys? And I don't know whether Don was in the audience or not, but she was saying that if the septics, she was after septics, Nancy, you're looking puzzled. 11 years ago, that was the first go-round on the septic ordinance, or the septic prohibitions, or what do you want to call it. And she was concerned that, by golly, 1 or 2 or 3 or a handful of systems will contaminate the Madison like forever. You never get it, once it's contaminated, you never get it out. It's not the way nature works.
Okay, that's what you were saying.
And I'm sorry if I know these two guys were there, and
Okay.
so anyway, thank you very much. Well, one other quick thing. You're talking about fixing the ordinance for penalties, and that's a problem. I don't want you to copy, but my experience in life has been, rather than reinvent something that needs to be fixed, look at what somebody else is doing. You live under a different government. You reside under a different government. I'd ask them, what's the penalty, Ron, if you don't get a permit? Or your neighbor doesn't get a permit? How does the city handle it?
Hopefully, we do that.
Well, but what I'm saying is, rather than reinvent, if the city has already been through this process, borrow from their ideas. And maybe you three people, do you know, Nancy, what your penalty is?
No, I don't.
Thank you.
Anyone else? If not, Holly indicated we have no need for a second executive session, so some creative person could make a motion.
To adjourn.
So I move.
Second.
Motion and a second to adjourn. All in favor, say aye.
Aye.
Opposed, motion carried.